pages 1 through 7. I want to make sure that the defense received the changes that my staff attorney made regarding, really, I think, just spacing and maybe on the verdict form, the size of the font. But the instructions are 7 pages long. Did you have the opportunity to review what we had discussed, the formatting changes, and can you verify that the defense is in agreement with 7.11?
Yes.
Okay. And the verdict form, it's now 3 pages long. It has some substantive, actually section E on page 3, as well as the 2 signature lines for the foreperson. Is the defense prepared to approve of this verdict form?
Yes.
All right. One other thing. There is no preliminary instruction to the closing arguments. Unless there's something specific you want me to say, I plan to just tell them when they're seated that the attorneys are now going to present their closing arguments.
Right, the state goes first and we go last.
Yeah. Yeah. Is there a rebuttal?
No.
I didn't think so.
No.
All right.
And so I'm clear. Are you just going to have us? You're just going to say turn to the state, or are you going to say anything?
No, I'm going to say the attorneys are now going to present their closing arguments. The state will go first, and then the defense will have an opportunity.
So I just want to make sure.
And then I'll say, is the state ready?
Yes, sir.
Yes.
We're renewing our objection to State Exhibit 1.
Well, I'm sorry, I didn't hear it.
We're renewing our objection to State's Exhibit 1, which Mr. Diaz has informed me he intends to publish to the jury in his closing argument.
I ruled on it coming in, I suspect, at some point. It was admitted.
It's State's Exhibit 1. It was the first thing I put in.
Okay. And there was an objection to it, but I admitted it over objection.
Right, now obviously it's being admitted for being published to the jury for different reasons, and so we're objecting to that photograph being published to the jury in order to establish he had.
I hear you. I'm going to allow it, though, over the defense objection. Are we state ready for the jury?
Yes, Your Honor.
Defense ready?
Yes, we're ready.
All right, let's get the jury.
All rise, jury in the courtroom.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good afternoon. Welcome back. Did everyone have a nice lunch? enough time? Did you enjoy the hour and a half? So I guess it was an extra 15 minutes than you've normally been getting?
Yes, John.
All right. Well, I'm glad to hear it. We are now, as I indicated before we took the lunch break, at the stage where the attorneys will have the opportunity to do their closing arguments in the penalty phase. It is just much like the guilt phase where the state will go first and then the defense will have an opportunity to give a closing argument, and then I will give you the instructions on the law, and then you will go back into the jury room to deliberate. So at this time, I am ready to turn to the state and see if they are ready to proceed. Mr. Diaz?
Thank you, Your Honor. Afternoon, everyone. As before, you'll be given a verdict form. I'll put it up here on the overhead so everyone can see. It is slightly different than what you saw before, but it still follows the same basic idea. You will be asked to make a decision, and you will reflect your decision here on the verdict form to tell us what your ultimate decision is. However, unlike before, where things were ranked highest offense and then subsequent offenses all the way down to not guilty, and you're only picking one, you're instead being asked to answer what is effectively a series of 5 questions: A, B, C, D, and E. And I submit to you that you will answer all of them because you will answer yes to all of them. So the first one is going to be, do you unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor? And as you may recall, when we talked about it before, there are 2 aggravating factors in this case. And so you have 2 separate inquiries under the first step, step A. The first part has to do with whether or not the defendant has previously been convicted of a felony involving the use or threat of violence to another person. And the second one, number 2, was the murder especially heinous, atrocious, or cruel? And we're going to talk about both of those in a second. But if you check yes to either one of these, though I submit to you you will ultimately check yes to both of them, it will then tell you, and you'll see this repeated over and over again, if you've checked yes, you're going to move on to the next step. If you check no, everything is done. The defendant gets life in prison and there's nothing more to discuss. So when you check yes as to 1 and 2 under A, you'll then get to B. And again, you may remember from jury selection, and I know that that's almost 3 weeks ago now, but you may remember from jury selection that the next question is, do you unanimously find that the aggravating factors are sufficient to warrant the possible sentence of death? And again, I submit to you that you will say yes. And so when you do, under B, you find that the aggravating factor or factors are sufficient to warrant death, you will move on to C. Now, C is a little different, and the judge will explain this to you, okay? But in this case, you do not have to be unanimous. As for A, B, D, and E, you will have to be unanimous in the decision of all of those. But for C, it only has to be one or more of you who finds that one or more mitigating circumstances were established by the greater weight of the evidence. And again, that's different than beyond a reasonable doubt. Greater weight of the evidence is you sort of think of it like the scales of justice. One just has a little bit more than the other, right? The greater weight. There's just a little bit more for one. And I submit to you that you will see in the instructions, I think it's 18 separate potential reasons for mitigation that are listed in the instructions. And you can contemplate all of them. And statistically, between the number of you that there are and the number of potential mitigators that you are, I fully expect that one or more of you will answer yes to this because you think that there is at least mitigation worth considering. And so when you check yes there, you will move on to D. And this will be the part that I talked about at length during jury selection. You'll get to the part where you have to decide, do the aggravating factors outweigh the mitigation, right? And again, this is not a numbers game. It's not, well, there's 2 mitigating factors and there's 2 aggravating factors, or there's 2 aggravating factors and there's only 1 mitigating factor, or there's 2 mitigating factors and there's 18 mitigating factors. It's not a question of numbers. It's not a question of quantity, it's a question of quality. It's the weight that you assign to the aggravators and the mitigators, and do you determine the aggravators to outweigh the mitigators? And in this case, I submit to you that you will find that the aggravators outweigh the mitigators. And so, as it tells you, you will then proceed to the last step. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, Section A, that the aggravating factors are sufficient to warrant the sentence of death, Section B, and that the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Matthew Terry should be sentenced to death. And I submit to you that the only just and correct verdict in this case is to check yes on all of these questions. Yes, the two aggravating factors have been proven beyond a reasonable doubt. Yes, they are sufficient to warrant the consideration of death. Yes, there is some mitigation, but yes, whatever aggravation there is outweighs the mitigation that might exist. And yes, the defendant should receive a sentence of death. So let's talk about aggravating factors, because that's obviously the first step. If there's no aggravating factors, the state doesn't even get off the ground. So you'll receive this instruction, 7.11, okay, and it has some opening explanations and stuff. And then eventually you transition to right here. The aggravating factors alleged by the state are: Matthew Terry was previously convicted of a felony involving the use or threat of violence to another person. And the instruction tells you very specifically the crime of assault with intent to do great bodily harm, less than murder, is a felony involving the use or threat of violence to another person. So it is legitimately as simple as going and looking at the certified copy of conviction and seeing that the defendant was convicted of that crime, and therefore the first aggravator has been proven solely by the certified copy of conviction. But beyond that, you heard from Ailish Gallagher, the prosecutor. You heard from Matthew Crumbach, the detective, who told you they were there the day the defendant was found guilty, what he was found guilty of. And you've heard from Michelle Rogers, who told you the circumstances, along with Detective Crumbach, who helped to get the pictures into evidence so you can see them. And you can see that clearly what happened in Lansing was a crime of violence. You know it's a felony, and it's a violent felony. You know the defendant's been convicted. The state of Florida has absolutely, positively, not even beyond a reasonable doubt, beyond all doubt, shown that the defendant has previously been convicted of a felony involving the use or threat of violence to another person. And so that brings us to this other one, which you probably haven't heard a ton about, so I want to talk about it a little more in depth. I want to remind you, as I'm sure you've heard 100 times, that the penalty for first-degree murder in the state of Florida, by default, is always life in prison. It falls on the state to prove the aggravators and to show that the defendant is worthy of consideration for the death penalty. Now, we've already done that with the first aggravator, but there's also this one. Heinous, atrocious, and cruel. And you may think, well, what does heinous, atrocious, and cruel mean? And the law defines that for you. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even the enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Kay Baker. And so I want to highlight a variety of things that I think you should contemplate in deciding whether or not the state has proven this aggravator beyond a reasonable doubt. And when you do, you will see that we have proven it. The first thing is, it ends with the notion of conscienceless or pitiless and was unnecessarily torturous. What Matthew Terry did to Kay Baker was conscienceless. It was pitiless. And Kay Baker suffered. She was tortured. And you might think initially that torture means, well, she must have been tied to a chair and like somebody was putting bamboo under her nails. But torture is an act of the mind of Kay Baker. Right? That's why it matters that she's awake. That's why it matters that she's still feeling the pain of every single time the knife is plunged into her. That's the torture. It's the fact that she knows what's coming. She's there on the ground, literally watching death creep ever closer to her. That's the conscienceless, pitiless, torturous elements that make this heinous, atrocious, and cruel. I want you to look again at the photos of the injuries Kay Baker suffers. I want you to contemplate what that had to be like. How many times she has to be stabbed.
Objection.
Can we approach?
Sure. What is Kay Baker experiencing? Is it painful? Is it scary? Does it rise to the level of torture? I submit to you that it does. But look at the entirety of the acts. Look at the entirety of the circumstances of what's really happening. It's not just the number of times she's stabbed. It's not just the locations where she's stabbed. It's not just the damage that she suffers. It's all the things she knows leading up into that moment. Kay Baker knows what the defendant is capable of doing because she knew he did it before.
Objection. Objection.
Overruled.
Kay Baker stood by Matt Terry through all the years. She even testified at his own trial. You heard from Mr. Terry's mother.
Continuing objection, please.
Absolutely.
She knew. There came a moment. And again, when we get to the issue of unanimity, you might decide where that moment comes. Does it come as she's running into the room to close the door? Does it come as she's throwing open the window? Does it come as she's crawling out the window? Does it come as she's running away from the home? But somewhere, it becomes real clear. It becomes real clear to her what she's about to go through. The terror, the pain, the torture that is coming. And Matthew Terry is the person who is going to give that to her, without conscience and without pity. And I submit to you, ladies and gentlemen, that those things that Matthew Terry did on that night, that you've already determined that he did, were outrageously wicked, shockingly evil. They were vile. What Matthew Terry did to the woman who loved him, the woman who invited him into his own home, the woman who had been his friend, both his personal friend and his family friend, for basically their entire lives.
Objection.
Was
Non-statutory aggravation.
Overruled. Move on.
It is evil and vile. The state of Florida has proven the two aggravators. And so you must now turn to the question of, are those aggravators sufficient to even contemplate a death penalty? And I submit to you that they are. This is not a murder where Kay Baker was shot in the head and lost consciousness instantly and felt nothing. That's not what this case is. This is not a case that is dispassionately done from a distance with a gun. This is up close. This is personal. You've got to get within inches of the person to plunge a knife into them over and over again. You've got to physically fight back against them and take whatever they're throwing at you for their own safety. These acts, the things that you've already determined that the defendant did, are sufficient to contemplate a possible sentence of death.
Objection. It's not the law.
Approach.
would ask that the jury be instructed to disregard the last statement.
Well, actually, yeah. Ladies and gentlemen, ladies and gentlemen of the jury, first of all, what the attorneys say is not the evidence or your instruction on the law. Your instruction on the law will come from me, from these instructions, and they will go back into the jury room with you. And this is the law that you shall consider, not what they say.
So
I'll ask you to disregard his last statement.
And so no one is confused. You will find the defendant's actions are sufficient to warrant a possible sentence of death. And you should find them. So I will not go step by step through all of them, but so that you can see them, just to get a feeling for them. On page 3 of 7 in the instructions, you'll see the mitigators. They go all the way to 14 on this page, and then they carry over to page 4 through number 18. And given that the standard is the greater weight of the evidence, the burden is the greater weight of the evidence, did Matthew Terry grow up in a loving home? Yes, he did. Absolutely. Does his family love and support him? Yes, clearly. I'm not going to stand up here and tell you that those things are not true. You heard the testimony of the people who said them. You know that they're true. Matthew Terry's mother and father clearly still love him, and all the other people who took the time to come down here from Michigan clearly still love him. So there's obviously some mitigation. I won't even waste time debating that. But the question is, do the aggravating factors, does the fact that the defendant has done this before, done a violent crime before, does the fact that the defendant did this act with such brutality, so conscienceless, so pitiless, that was so torturous to the victim, does that outweigh the mitigating factors? And I submit to you, yes. You've heard the testimony from the various people who came to talk to you about the mitigation, Mr. Land, who came to talk to you about the Florida Department of Corrections, and the family friends of Mr. Terry, and even the detention deputy from the jail cell where Mr. Terry was. And nothing about any of that will outweigh the aggravators in this case. The aggravators will always outweigh that mitigation. At some point, Matthew Terry took State's Exhibit number 73. And turned it into State's Exhibit number 1.
Objection. May I approach, please?
Yeah. When you go back, you'll have all the evidence that you had before, plus the additional things that have been admitted here. And so, look at the pictures. Look at the pictures of the autopsy, or the picture of State's Exhibit 1, or all the other pictures, and ask yourself, was the actions that caused the death of Kay Baker, were they heinous, atrocious, and cruel? And they were. Were they a repetition of a violent act when the defendant had already been convicted of a violent act before? And that's absolutely the case. The aggravators in this case tower over the mitigation. It's not just a little bit on the scale. The aggravators slam down in comparison to the mitigation. At the end of all of this, you must ask yourself, should the defendant should he be sentenced to death? And I want to be really clear. If you remember all the way back to jury selection, I think it was Wednesday or Thursday, depending upon which group of people you were in, I started it the same way for every group. I stood up and I told you that this is real. It's not hypothetical. It's not theoretical. We have never tried to minimize what we are asking you to do. I told you up front, it's another human being. Right? I told you that. We've never tried to pretend that it's anything less than it is. But where we are now is we are in penalty phase. And as we discussed with you during jury selection, this case is different because you guys decide the sentence. You guys decide the punishment. You decide what is appropriate. And so I want to remind you that though it may be hard, you agreed to follow the law. The state of Florida has proven the aggravators. They are sufficient, and they do outweigh the mitigators. And so we ask that you deliberate. And I really want to talk about that. This is the last page of the instructions the judge will give you. And I want to point out the word that appears over and over again in its various iterations. It is during deliberation, while you deliberate. Help you in your deliberations. When you begin to deliberate, the judge cannot participate in your deliberations. I expect that Mr. Kane will get up here and tell you that you each have to make an individual decision, and that is absolutely true. You each have to make an individual decision, and it has to be unanimous at the end of the day. That is the case.
Objection.
Legal basis? An approach?
And so, when you go back and you deliberate, I submit to you that when you consider all of the evidence, both from guilt phase and from penalty phase, both the things that you heard from the state and from the witnesses the defense put on, you will reach one conclusion. The defendant should receive the death penalty. He should be sentenced to death. And so we ask you that you go back and you take the time to think about the things that have been put before you from both sides. And to use your common sense. And remember that because I have the good fortune to have done jury selection, I know all the lawyers are sitting on this side. None of you are lawyers. We're asking you to use your everyday common sense as people. To look at what happened. To look at what happened to Kay Baker. To look at what was done to Kay Baker by the defendant. And to recognize that what was done to her was the act of a person who was already a convicted felon for a violent crime, who was doing something especially heinous, atrocious, and cruel. Something conscienceless, something pitiless, something torturous to Kay Baker. And when you do, I submit to you that you will look at the verdict form, you will check yes all the way down, and you will reach the only correct verdict in this case. Thank you for your time.
Mr. Kane?
Thanks, sir. Please the court, ladies and gentlemen of the jury, counsel. It is true that you're not lawyers, but you are judges. And let's see, how does this work?
Hit the bottom button now.
Oh, perfect. There you go. Thank you. You are judges. Each one of you is a judge in this case, and each one of you is going to be deciding your individual moral sentence. That's what you're going to do. And a lot of what Mr. Diaz has talked about, a lot of what you see in the jury instructions is what has been shown to you through voir dire. We talked to you endlessly about what it means to be seated where you are seated. Every time you come and go from the courtroom, we stand. You are the judges. You are going to be given the law. You are armed with all the testimony for you to sort of extract from that what the facts are, and then you proceed to that individual decision. If individually it happens to be unanimous for death, then that is the sentence. That decision does not rest anywhere else except with you. That's where we are. I mean, as complicated as it may sound, and you've been listening to objections, you've been listening to us argue sometimes from the trial table, and as complicated as all that may seem at times, it's really not. This is where the law is sort of reduced to its most perfect simplicity, the perfect jury system, where we have 12 individuals who are going to go back there who have never met each other, who have known each other for about 3 weeks now, and at this point decide whether or not something has been proven. And then you're going to decide whether or not a sentence should be imposed. Your sentencing function is about as serious as it gets. This isn't a civil case where we're talking about property rights being lost or restoration through money being given. This has nothing to do with that. In many ways, it's not even about liberty. You're not deciding whether or not Mr. Terry is going to be a free man. This has nothing to do with liberty. It has nothing to do with money. You're deciding whether or not his breath will be taken away from him. And you've already decided, as a matter of law and as a matter of fact, that he took the breath from another person. And the pictures aren't pretty. They're horrific. There's loss. And we've been reminded of that on both sides through Matt's mother. The pain and the anguish. Yeah, they knew Kay. And so we kind of walked through the process a little bit. That's who we're here talking about at the moment. There's your decision. That's the bare bones decision, isn't it? That is he going to continue with the life sentence that you've already imposed, or are you going to take it to the death sentence, to execution, right? That's it. Just those two things. Nothing else. It's not life, death, possible release, probation, parole. No. It's as simple as it gets, just those two words. That's your decision. And there's obviously the verdict form takes you through that. It seems a little bit complicated, but that's what it comes down to. So you have already decided by your verdict, and we talked about this in opening statement, we talked about it in voir dire, that if you decide that he's guilty of first-degree murder, you have already decided where he's going to die. Now, your only decision is when. Is it going to be sooner rather than later? That's it. So we're talking about a calendar. Is the governor going to appoint the date that he dies based on your decision, or natural causes? whenever that may be. In other words, you're deciding, is it going to be known or not known when he's going to die? So we're really talking about a date, aren't we? That's it. And when we say life, we mean life in prison without the possibility of parole. That's a fact. It is a fact that he's never getting out. So is public safety really a concern? And what does life in prison without the possibility of parole really mean? It means so many things. When we were looking at the family photos, what were the things that Matt was attending? He was attending birthday parties. He was attending family gatherings. He was attending weddings. He was there with his friends. He was there with Benjamin Williams and his cousins. He was there with all those people. You saw him with his daughter. Now, regardless of your sentence, regardless of your verdict, that was never going to happen again. He's already lost his daughter. Just like the Terrys have lost a grandchild. Just like the Bakers have lost a sister and a daughter. There's loss everywhere in this case. Everywhere. He's never going to get married again. He's never going to have a girlfriend. He's not going to attend a graduation. None of that. It's gone. So when you wonder and you ask yourself, is life in prison a kind of forgiveness? Life in prison is not forgiveness. It's condemned. It is decided for him when he gets up. It is decided for him when he can turn on a light. He doesn't even turn on lights. Light switches don't exist in cells. It's decided. You must get up. You must do this now. You must go here. You must work. Otherwise, you're in solitary. You're in confinement. Indeed, when you think about it, perhaps life in prison is a kind of mercy. But it is not forgiveness. It is not excusing anything. You're simply deciding, and you're not limited to those 18 things that we have identified as mitigation. That's just some things that you may want to consider. You can expand your thoughts on mitigation as far as you wish. It is your privilege. It is your honor as a judge in this case to decide what is mitigated. The state can't ask you to do that with aggravation. Your reasons for death are fixed by statute and fixed by law, but not mitigation. So, how's it going to die? How's it going to happen? With a pen on a piece of paper with a death warrant? Or some other time? There are your choices. You've already decided his death while serving a life sentence, and the state is asking you to impose execution. These are different ways to look at the duty you've been given. So, does a life sentence require any of this? Now, when Mr. Diaz put up there in front of you, he put up for you a part of the verdict form or a part of the jury instructions that talked about deliberation. Now, what does it mean to deliberate? It does not mean that you are required in any way to discuss your decision. It does not mean that you're required in any way to go back there and go through all the aggravation and go through all the mitigation, go through all the processes. You are not required to even get to step one. You can go back in that jury room, every single one of you. It is possible for all 12 of you to go back in the jury room and just say, life, life, done. It's possible for 5 of you to do that. It's possible for 4. It's possible for 1 of you to go back in the jury room and say, I'm ready to go home, the decision is life. We don't need to discuss it. So, if you do that, and as we talked about in voir dire, can 11 other jurors impose on you the obligation to explain yourself? Can 11 other jurors impose on you the obligation to talk about it, to deliberate, to go through the jury form? If one of you does that, if one of you says the sentence is life, the foreperson must go through and check no on each one of those things. Why is that? Because you've never reached unanimity on number 1. If one of you says immediately, life in prison, that's it. So let's say you all decide, collectively or individually, you decide individually that you're going to discuss what's been testified to, or you're going to discuss the aggravation. You are allowed to do that because each one of you is a judge, and you decide for yourself how far this case has been proven. So in other words, deliberation is not up for a vote. Deliberation is, if you want to deliberate, you may. If you don't want to deliberate, you do not have to. But if, at any point, you decide that the sentence is going to be death, you must go through each one of these things and vote on it. That's the difference between life and death. That is the difference. That is what the law has required in order for the state to ask for the most extreme penalty. Okay? If you do not reach unanimity, if you do not believe that at least one aggravating factor has been proven beyond reasonable doubt, the sentence is life without the possibility of parole. If you are not unanimous that the aggravation is sufficient. Now, what does that mean? Remember we talked about compare that to other cases where the death penalty may be sought. Compare that to, let's say, somebody, a spouse hires a contract killer to hire the other spouse, or to kill the other spouse for insurance proceeds. And it's not gruesome. And you think to yourself, is that sufficient for the death penalty? The one spouse didn't actually commit the act. They hired somebody to commit the act, and that's terrible. They did it for pecuniary gain, so we have cold, calculated efforts to take another human life for money. But do we feel that that is sufficient for the death penalty? You may say no. In this particular case, you may not unanimously agree. It's possible that not all of you will agree that this is sufficient for the death penalty if you agree that at least one aggravating factor has been proven. That's intuitive. It's intuitive. What do you feel? Do you feel? Now, there is no standard. Isn't that interesting? Where's the guidance? This, in many ways, really, because this is fact-driven, what is this? Sufficient. Who tells you what's sufficient for something and what's not sufficient? Who does that? Can the state get up here and say, you must find that whatever aggravation I have proven is sufficient for the death penalty? That's where the individual moral assessment begins. How can each one of you tell the other what's sufficient and is not sufficient? Isn't number one very much like the case for guilt? is number 2 in any way at all like the case for guilt? What you believe is sufficient may be different. What you believe is sufficient may be quite different. You. It's individual. And then you talk about it. And if you're unanimous, if every one of you agrees, then you go on to the next one. How about outweighs the mitigation? Where's the guidance to tell you whether or not something outweighs the other? Do you have a scale back there? Perhaps if you were to create an image of the scales of justice, and we were to ask you to take the mitigation and sort of compare it to the aggravation, and you know what's interesting? Take away the imagery. Take away the imagery of those photographs of Kay Baker. Just take that away. Do you have a different view of the case? Why is it that the state paraded those images in front of you? Why is it that the state put up there a before and after? Why do that? What's the purpose in the before and after? When really their aggravation must be prior violent felony or especially heinous, atrocious, and cruel. Do you need the picture of Kay Baker in a happy pose in the glory of life to imagine that the second photograph, moments after her death, is horrible? What's the state telling you? I've got to give you this image in order for you to fully understand this one? Or is he trying to appeal to you in a way that is outside what you're supposed to consider? So, even if you get to all of it, are you unanimous that the sentence is death? If you are not unanimous that the sentence is death, then the sentence is life without the possibility of parole. And why do I keep hammering home without the possibility of parole? Because that's what it is. That's the sentence. So look at that unanimity. And then at each stage, one of you, if one of you disagrees and one of you says life, that's what it is. So, that's as real as it gets right there. It means that at any one of you at any point can get up, knock on the door, tell the court deputy that the final decision is made. Your final decision is, in fact, the sentence. Because at that point it is no longer unanimous. It is not disrespectful to say the sentence is life. It is not rude. It is not unkind. It is not lacking in courtesy. It is not a failure to respect the opinions of other jurors. It is your individual moral assessment, and it will be respected by your other jurors. It's going to be respected by this court, and that will be the sentence. And it will be the sentence because it is an individual moral assessment. That's why the sentence will be imposed. One of you has the power to do that. So, when we look at mitigation and aggravation, what are some of the things that we consider? If you get to the weighing process, I want you to understand that mitigation is anything from any source that you believe supports a life sentence. Right? It can come from the case itself.
Maybe there's something that you heard in either Mr. Diaz's examination of his witnesses, or maybe there's something that you heard in Ms. Perry's cross-examination of the witnesses that convinces you, as you look back on the case in chief, that this is not necessarily a death sentence. Because when we're talking about prior violent felony, does the prior violent felony have anything at all to do with the facts of this case? In other words, when the state says prior violent felony, what they're really doing is they are gathering aggravation from someplace outside the facts. Prior violent felony is some other thing at some other time in some other place involving somebody else. That's prior violent felony. So when we're looking at this case, in this case alone, just this case, just what happened on May 28th, what is the state's aggravation for it? The manner. That's it. One word. When it comes to what actually happened, the only basis, the only support for a death sentence in this case is the manner. So when you look at mitigation, if you wanted to, as individual judges, if you wanted to, you could say that I'm looking at just this case, even if you find PVF. Let's imagine for a second that you find PVF and you find EHAC. When I say EHAC, we mean especially heinous, atrocious, and cruel. Let's say that you do that. You could find mitigating the fact that the state is only supporting its death request of you on one element: the manner. You could find that mitigating. And what are we really saying? If you wanted to, because mitigation can come from any source that you believe supports a life sentence, you can look to the facts of the case. You can look to what you believe is insufficient. And that's what we're really talking about here, is sufficiency. You can say, I'm sorry, but when it comes to the facts of this case, I do not believe it's enough that a death sentence be supported on one aspect of it, even though the law permits you to do so. And we're talking about comfort level. What are you comfortable with? When you get down to the final analysis, what makes you comfortable? What makes you uncomfortable? What is going to give you peace and have you walking away from this believing and knowing that the right decision was made, regardless of what that decision is? And because this is an individual moral assessment for each one of you, that means that mitigation can also be very personal. Very personal. And remember the discussion that I had with one of your jurors. And we talked about that in opening, that often our reasons for doing something just can't be expressed. It's just a feeling that you have. And if it's just a feeling that you have, that takes us back to yourself as a source for mitigation. You can look to the case. You can look to yourself. You can look to your comfort level. Any source means any source. If you wanted to, you could support a life sentence on this. Matthew was raised in a loving and prosperous home. If you wanted to. And the other important point that I want to make is that you don't have to have mitigation. mitigation is not required for a life sentence. You don't, even if you have no reason at all that you can point to, whether it's in the case or internally or externally or whatever you may wish to rely on, even if it doesn't exist, you can impose a life sentence even if you believe that all the aggravation has been proven, even if you believe the aggravation outweighs nothing. Even if you believe that the aggravation outweighs nothing, meaning that there is no mitigation, meaning that there's just aggravation. There's just aggravation. There's nothing to compare it to. The scales are horribly imbalanced. You can still impose life. Please understand, life does not require mitigation, even though it can come from any source. And if you do want to look to mitigation, if you're hoping that you find it, then you can look to the fact that Matthew was raised in a loving and prosperous home. I think everybody can agree on that. He was a United States Marine who served honorably and faithfully. He tutored inmates seeking their GED in the Michigan Department of Corrections. As Aubrey Land talked about, that can be very important. Now, when we talk about Aubrey, it's very important to remember that Aubrey cannot always help in these kinds of cases. As you heard him say, often when he looks at these records, he'll contact the defense and say, I can't help you. I'm sorry, I cannot testify in this case. That's impartiality, and it means that he is objective. And it is not disputed that Matt tutored other inmates in the Michigan Department of Corrections. It's not disputed that he helped other inmates do that. It's not disputed that he had no disciplinary infractions in prison. Now, you heard Mr. Diaz talk about, well, isn't it true that that's what inmates are supposed to do? We don't compare our conduct with an inmate's conduct. That's an unfair and inappropriate comparison. It is expected, yes, that all of us obey the rules. You're sitting here now because you're law-abiding citizens. I'm standing before you as a law-abiding citizen. The same as Mr. Diaz, Mr. Dirks, Ms. Spradley, Ms. Perry. Matthew Terry does not fit into that category. So what is the point of comparison? We don't compare him to those on the outside. We compare him to those on the inside, where you heard Deputy Machado talk about how dangerous it is. What is he up against in a pod of 65 inmates? Deputy Machado is always looking over his back while having to look out for what's in front of him, paying attention to all those inmates who want to deal drugs, all those inmates who have it in for each other, all those inmates coming in off of gang warfare, all those inmates coming off of drugs, all those inmates in there for violent crimes. Matthew Terry is in there and among that population. That's the population you compare him to. In that setting, what Aubrey Land is saying is that in that setting, Matthew Terry conducts himself like one of us. He doesn't get into fights. He doesn't get into drug dealing. He doesn't get into underhanded activities designed to usurp the authority of prison guards. He doesn't put other inmates in danger. He is assisting other inmates in getting through those issues so that they can move on and eventually communicate as productive citizens, sending letters to judges. You see? That's the population you compare him to. And in that setting, he is perfect. He's had no problems at Hillsborough County Jail. He's a trustee. He earned a degree in computer engineering from Western Michigan University, and you heard Aubrey Land talk about how valuable that is and what that could mean within the Department of Corrections. I had no idea that every time we go through a toll, there's an inmate in prison entering that information, that transaction. I had no idea about that. But apparently it's a very valuable thing. And Aubrey talked about that if something happens with that system, Matthew is perfectly positioned to save the department a lot of money. And he's willing to do it at 75 cents an hour. Now, when Matt first got into trouble, and the event happened in March of 2017 with Michelle Rogers, Matthew was 42 years old. And at this point, he's 47, which means that his problems really didn't start until he was in his 40s. There's no record of any sort of criminal activity or conviction or anything like that prior to 2017. And I don't think anybody really is in a position to explain that, and I don't think that we got any idea of what happened from those who love him. And so what am I talking to you about here except mystery? In order to give Matt a life sentence, do you need an explanation for what happened? Because it's not out there. We can't say it was the loss of Jessica because Jessica died a couple of months after he was given a prison sentence. So what has happened? And so what we're asking you to do is to go forward not having all the answers to things. Sometimes we do. Sometimes we can talk to doctors. Sometimes we can ask experts. We can say what's going on in the mind of this individual. And those who love him and know him best have no idea. None. We know that. We know that he's loved by people who continue to be present in his life. That is valuable. We know that Matt will be punished in prison and society will be protected. If there is any concern that you may have for Matt being a danger to society, that has been removed by your verdict. You've had the opportunity to watch Matt in court. You've had the opportunity to see him sitting here at the trial table, and we would ask you to factor that and give that any amount of weight that you believe is appropriate. Now, we know that Matt has the ability to succeed in a highly structured and controlled prison environment. As we know, he was in the military. As we know that he's been in prison. And each one of those records, whether it's the Marine Corps, Michigan DOC, or Falkenberg Road Jail, those records are spotless. We know that he has the ability to form and maintain positive relationships. That's clear from the testimony of the witnesses. It is mitigation that he will be sentenced to life without the possibility of parole if you are not unanimous. That is mitigation. So we get to the Terry family, and each one of these individuals testified quite differently. Each one of these individuals, whether it's Mark, Kathy, or Jane, those are members of the Terry family that you heard from. Jamie Robertson is Kathy's sister. So each one of those individuals sort of expressed themselves quite differently. But their message was the same. And that obviously it's not a surprise that Mark loves his son. It's not a surprise that Mark loved Jessica. It's not a surprise that Kathy loves her son. Or Jamie loves her nephew. But the question is, how are you going to assign weight to that? Is does that, in and of itself, communicate to you that Matthew Terry has value? Because what's the point of value? Anything that has value, we keep. Even if it's hurt us. Even if it's caused us pain. We keep. In some manner. I'm not saying that we always embrace it. I'm not saying that we invite it home. I'm not saying that we let it around our children. What I'm saying is that we recognize that something has value and we keep it. We let it persist in some way. Because value is value. Right? And so it doesn't matter if that value is found in the Terry family. Now, remember Ben and Ruby? I would imagine that each one of you was impacted quite differently. If you remember how Mark or Jamie may have come across, and then Ruby got on the scene. Ruby and Kathy, mothers to Matthew Terry. Those two are his mom. Both of them. Ruby raised Matt. Kathy raised Matt. Ruby's sons are Matt's brothers. That was very real. She spoke to him from the stand like a mother. She sat up here, looked at him, and said, "You know what you did." Who says that to a man? When she was saying that to him, did you feel hatred or sorrow? The tragedy of what happened to Kay extended fully from the Baker family right into the Terry family. That tragedy has no boundaries. That sorrow, that loss, the depth of grief has no boundaries. It doesn't stop. It keeps going. Ben loves that man like a son. And you just heard me say that man. Ruby loves that man like a son. I couldn't question Kathy any longer. There were many more things that I would like to ask Kathy, but she was done. Steve was nervous, and he sort of testified like a nervous man, but his nervousness did not affect his sincerity. He's another individual who's come across Matt in his life and just has this inexpressible love for him. And even though they didn't see each other every day, Steve has suffered the loss of a child. Steve suffered the loss of a child and needed somebody to speak on behalf of Johnny. And of all the people that Steve knows to speak on behalf of Johnny, he picked Matt. Now, Matt, in that loss, had lost his best friend. They grew up together. They were like brothers. And think about everything that I'm talking to you about here is that the relationships that we're exploring are not limited to just the people who have testified. Often you've heard people testifying about people that Matt knew who are not here today. if I lost my best friend or lost my brother, I'm not sure I could eulogize it. I'm not sure I could do that. I'm not sure I could do what the Bakers have done here. But in our loss, sometimes we set that aside in order to express that love, that sorrow, that grief, and that's what Matt did for John. And when that need arose, Steve Glassner called upon Matt to do that for him. And however painful that must have been, Matt was able to do that, set something aside about himself in order to say those words. And again, we come back to value. Yes, Matt has taken a life. But does that mean he's inhuman? Does that mean that he lacks value? And I'm sure that there are some people in this courtroom who would say yes to that. But they're not the ones making this decision. Do you gather from any of the defense witnesses or any of the state witnesses or anywhere else that Matt has value? And we talked about Aubrey Land. Now, the law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular fact or circumstance. You decide what weight must be given. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, Mr. Diaz is walking you through that process. But what he didn't say was that the law neither compels nor requires you to determine that the defendant should be sentenced to death. Never. The law is perfectly satisfied with a life sentence. You have not offended the law. You have not offended anyone in this courtroom. You have not offended the judge. You have not offended anyone by a life sentence. You're going to be read that. That's in the jury instructions. That is the law of the state of Florida. So, if the jury instructions are the law that we must follow, what are we being told? What we're being told is that each individual juror must decide according to each juror's individual weighing process. And that even if you unanimously agree that the aggravation outweighs the mitigation, you are never compelled to impose a death sentence. That's the law, right? So each of you individually has the power to sentence Matt to life in prison. And even under the most unanimous circumstances as you go through, each of you has the power to impose life. And as I've talked to you about, mitigation does not need to be proven in order for you to sentence Matt to life in prison. What must be proven and walked through in order for a death sentence to be imposed, and that's aggravation. At every step, there's aggravation. In a weighing process or in having to find it, and then when you finally get to the last sentence, even if aggravation has sort of dominated the entire analysis, you can still sentence to life. So that's because mitigation doesn't need to be proven. You do not have to have any reason at all for a life sentence. Zero. And because you don't have to have a reason, you do not need to explain that to other jurors at any point. And we've talked about where the moral assessment can come from. What are its origins? What is the origin of morality? Origin of morality can be from any source, just like mitigation can be from any source. Often morality is just a feeling that you have that comes from personal experience. And each one of you has a different personal experience. Sometimes we can get caught up in things like premeditation, things of that nature. I would ask you that when you go back there are certain things that you have already decided by your verdict. What you have decided by your verdict is that Matt deliberately committed this act. What you have decided by your verdict is that he thought about it. What I'm going to ask you to do as you go back there is to not consider anything that you have already found that is not within the aggravation. So, when you talk about, okay, this is what was going on in his relationship. This was what was going on in Michigan. All these other things that are external to the facts of the case that the state has asked you to consider. Please do not consider anything that is not confined to the aggravation. Okay? The elements of premeditated first-degree murder were already chosen by you, were already voted on by you, and unanimously agreed to. And I would encourage you not to discuss what is premeditation or what is already decided. Now, these are my final words to you, and I want to thank you for all of your attention and everything that we've talked about in voir dire, because I've spoken to each one of you individually. And it's been a 3-week journey, and we're at its end. And in a few minutes, you're going to be given this case. And you all know each other pretty well by now, I suppose, and you've all spent a lot of time together, probably know each other's first names very well. And I would ask you that when you go back and you deliberate, that if you are not in agreement, that you respect that. I don't imagine that any one of you would try to put pressure on another juror to share the same feelings. If you wish to discuss it, you may discuss it. But if it's just something that you don't feel can be expressed, then say that. And it will be respected. You all agreed in voir dire that, I'm not going to bully, I'm not going to impose my beliefs on somebody else, just like we don't impose on each other churches and jobs, hair color and hair length, and what kind of car we drive, whether or not we're going to have kids, where we're going to live, the books we read, all those individual things that sort of make up our identities. Because an individual moral assessment is part of who you are. And you don't need to justify that. If you want to talk about it, sure. If somebody asks me the basis for my faith, and I want to talk about it, I do. I share that. I'm prepared for that. But if I don't want to talk about it, I don't talk about it. And this verdict, this process that you're in, that you're going to remember the rest of your lives, This is not just, you're not just passing by something on the road. You've really stopped and you're looking at it. You're going to remember this. You're going to remember the folks you're with. It's going to become a very important part of your concepts of the law and what happens in court cases and each other. Some of you may continue to be in touch with each other. That's all a part of what's happening here. And then when you get to that point, when you're finally making a decision and you're asking each other, what do you think? What do you believe is appropriate? It's going to be with courtesy and respect. No resentment. And the reason why we're asking you for life, the reason why we're asking you, and our position is that Matthew Terry's sentence should be life, is because life is worth preserving. Life has value. The state's aggravation does not outweigh the mitigation wherever you may find it. It doesn't outweigh the things that I've shown you could be mitigation if you choose to be. If you choose it, that's fine. You're going to hear about it. Mitigation has to be proven by clear and convincing evidence, greater weight of the evidence, a burden. No. You'll hear that the defense has a burden of proving mitigation, but that's if you take what I've shown you, and if you believe it's been proven, you can accept it if you want to, but you are not limited to those reasons. And when I asked you, when I just told you, we're asking you to impose a life sentence. Each one of you is a judge. I'm asking you to impose a life sentence. Why? Because either the reasons that I've given you or the reasons that you find within yourself are sufficient for life. All life has value. Every bit of it, every breath, every heartbeat. Matt has value if for no other reason, than he is loved. And even if I couldn't call one person up here to say that they love Matt, I would find value. I'm not going to stand up here and say what he deserves. I'm not the judge. I am going to say that he deserves to be punished. I am going to say that he deserves to die in prison. He deserves to die in prison. I'm not going to sit here and say that a life sentence is unjust. It is not. It is perfectly just. And you are in no way forgiving him for anything by imposing a life sentence. I'm asking you, find value that outweighs anything that you have seen or heard in this courtroom. Find value and sentence Matt to life. Thank you.
Ladies and gentlemen of the jury, I'm going to read you the instructions. And these instructions will go back into the jury room with you. You will have them when you begin to deliberate. Members of the jury, you have heard all the evidence and the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. Number one, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1. Matthew Terry was previously convicted of a felony involving the use or threat of violence to another person. The crime of assault with intent to do great bodily harm, less than murder, is a felony involving the use of threat of violence to another person. Number 2, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with other indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily tortuous to K. Baker. You have heard evidence about the impact of this murder on the family and friends of K. Baker. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by K. Baker's death. However, you may not consider this evidence as an aggravating factor. As explained before, the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if, having a conviction, it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1. Matthew Terry grew up in a loving home. 2. Matthew Terry's family loves and supports him. 3. Matthew Terry is loved by people who will continue to be present in his life. 4. Matthew Terry has the ability to form and maintain positive relationships. 5. Matthew Terry is a generous person. 6. Matthew Terry was a United States Marine who served honorably and faithfully. 7. Matthew Terry earned a degree in computer engineering from Western Michigan University. 8. The age of Matthew Terry at the time of the crime. 9. Matthew Terry has exhibited appropriate courtroom behavior. 10. Matthew Terry will be punished in prison and society will be protected. 11. Matthew Terry has the ability to integrate into a highly structured and supervised environment such as Florida State Prison. 12. Matthew Terry tutored inmates seeking their GED in the Michigan Department of Corrections. 13. As a tutor, Matthew Terry was described as dependable, prepared, and willing. 14. Matthew Terry had no disciplinary infractions in the Michigan Department of Corrections. 15. Matthew Terry has conformed to incarceration and has had no disciplinary reports while incarcerated in the Hillsborough County Jail since his arrest on May 28, 2022. 16. Matthew Terry will be sentenced to life without the possibility of parole if the jury does not unanimously find that the death penalty is warranted. 17. Matthew Terry's family has visited him in jail and prison and will maintain a relationship with him. 18. The existence of any other factors in Matthew Terry's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose a sentence of death must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. Now hold up, it is a 3-page verdict form, and I'm going to do the same thing as in the guilt phase. I'm going to take it out of the stack, place it on top, so you'll have the verdict form and then the instructions that I've read to you right underneath it. This verdict form, as I said, is 3 pages, and it is titled Jury Verdict Form - Penalty Phase. It then reads, we the jury find as follows as to Matthew Terry in this case. A reads, aggravating factors as to count 1. Under that, there is the number 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Matthew Terry was previously convicted of a felony involving the use or threat of violence to another person. Then in parentheses it says check only yes or no, and then there are choices, 1 for yes and 1 for no. Number 2 under that reads, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was especially heinous, atrocious, or cruel. Then in parentheses it says check only yes or no, and then there are choices, yes and no. Under that it reads, if you answer yes to at least one of the aggravating factors listed, please proceed to Section B. If you answered no to every aggravating factor listed, do not proceed to Section B. Matthew Terry is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. Turning to page 2 at the top is Section B. Section B reads sufficiency of the aggravating factors as to count 1. Under that it reads reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt. In parentheses it says Section A. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Then in parentheses it says check only A. It says check only yes or no, and then there are choices yes and no. After that, it reads, if you answer yes to Section B, please proceed to Section C. If you answer no to Section B, do not proceed to Section C. Matthew Terry will be sentenced to life in prison without the possibility of parole. Under that is Section C, which reads mitigating circumstances. Under that, it reads one or more individual jurors find that one or more mitigating circumstance was established by the greater weight of the evidence. And then in parentheses it says check only yes or no, and then there is a choice for yes and a choice for no. Under that it says please proceed to Section D regardless of your findings in Section C. Under that is Section D, which reads eligibility for the death penalty for count 1. Under that it reads, the jury unanimously find that the aggravating factors that were proven beyond a reasonable doubt, parentheses, Section A, outweigh the mitigating circumstances established, parentheses, Section C above, as to count 1. And then in parentheses, the instructions check only yes or no, and then there is choices for yes and for no. If you answered yes to Section D, please proceed to Section E. If you answered no to Section D, do not proceed. Matthew Terry will be sentenced to life in prison without the possibility of parole. I then turn to page 3. At the top is Section E. Jury verdict as to death penalty. It reads, having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, in parentheses, Section A, that the aggravating factors are sufficient to warrant a sentence of death, parentheses, Section B, and the aggravating factors outweigh the mitigating circumstances, parentheses, Section D, we, the jury, unanimously find that Matthew Terry should be sentenced to death. Then in parentheses it says check only yes or no, and then there are choices for yes and for no. Under that it reads, if your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Under that it says dated this blank day of November 2022 in Hillsborough County, Florida. And under that there are 2 lines, one for the foreperson of the jury to sign and one for the foreperson of the jury to print their name. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Number 2, did the witness seem to have an accurate memory? Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, did the witness's testimony agree with the other testimony and other evidence in the case? Number 6, had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe the person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your decisions will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits in evidence, and these instructions. Number 3, your decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Number 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decisions. Number 5, your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. In just a few moments, you will be taken into the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. That is the form that will be on top, the verdict form that I've already read to you. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, so I am putting the stack of instructions. I'm putting the 3-page verdict form, and I'm going to paper clip the verdict form just to separate it. And we're going to send 12 of you back. Mr. Gonzalez, you are still our alternate. So I'm going to have you... Record to reflect, I am putting the instructions, page 1 through 7, right here on the edge of the bench. On top of it, I have the verdict form, pages 1 through 3, with a paper clip. You are welcome to inspect it before it goes back, as well as all of the evidence. Let me ask, is there any objection to the instructions as given at this time from the state and the defense? All right. Is there anything from either side before we go into recess until we hear from the jury either a question or a verdict?
Yes, we have one issue.
All right.
Yeah.
One thing, we just want to be sure that the victim impact evidence is not going back with the jury.
Not a problem. Let's make sure that,
Wait, you mean the photos?
Victim impact evidence does not go back
It's
into
not
the
go back, it's not
deliberation. It
considered.
cannot be
They can
considered.
only consider aggravation, that's not aggravation.
It's evidence.
It's
That's
different.
right, it's victim impact evidence. It does not-
wait,
One
let's,
person, please.
yeah, one person. We'll get through this. Trust me, it's all right. Well, I'll give everybody an opportunity, and I'll make a decision. But I want to distinguish first between the victim impact statements, which is the two written things. What exhibit is that?
It's not an exhibit. I didn't put the statements in.
Okay, so statements are not, but we will also make sure that they're not somehow put and sent back. They are not an exhibit.
He did put in the photos.
Photograph of Kay Baker and her children, and that jury may not consider that in their deliberations on whether or not they're going to impose a life sentence or a death sentence. They can only consider the aggravating factors. So the victim impact evidence that is introduced does not go back into the jury room.
But aren't those exhibits that were introduced part of the aggravating factors? Evidence of the aggravating
The
factors?
The victim impact, he published the comparison photo, which is what I objected to. He used the victim impact photographs and compared that to what was in evidence.
I cleared that with Mr. Kane before I even started closing. I showed him both of the photos, and I said, these are the only two photos I plan on using. And he told me he had no objection, because if he had, I would have addressed it with your honor.
Talking about
So why were they treated differently and introduced as exhibits when the statements were not introduced as exhibits? Why is that
The
distinguishable?
victim impact evidence should not have been introduced into evidence. We acknowledge that it was introduced, but they may not go back into the jury room.
So you're referring to the photographs now.
Just-
What numbers?
The photographs are 72A through D, 73, and 71A through D.
And your position is that you did agree to them, there was no objection to them coming into evidence, but you should not have done that. They should not have been entered as exhibits.
That's correct. They should have been introduced as court exhibits at the very least. They should not go back in the jury room.
Okay, this has to come up in every, and I believe it did in our last death penalty case, which many of us were involved in. And as I sit here right now, I don't remember exactly what I did. I think I know what I did, but I'm not going to speculate. But authority, Ms. Perry, show me a case that says that the photographs don't go back during phase 2.
If you could just give me a.
Absolutely.
And Your Honor, in the absence of a case, the defense position is that what goes back into the jury room is only what the jury may consider in determining a death sentence. Right now, they're deliberating on life or death.
But are they not are they not also considering whether the crime was atrocious, heinous, or cruel?
But the pictures of Kay Baker don't come in for that purpose. They came in for victim impact. This was introduced in victim impact, sir.
But they were also introduced during the trial, and they're told that they can
No,
consider.
these were not introduced during the trial.
No, oh, well,
These were
Penalty
introduced.
phase.
They're penalty phase exhibits. They were introduced during the victim impact when you published the photographs and
some of them. Their number 1 was introduced during the trial.
Yes, all of these were testified to by victim impact witnesses. This was not introduced for aggravation. Right now, the jury is deliberating. They may only, according to your instructions, they can only consider the aggravating factors. They may not consider victim impact evidence as aggravation. So, the defense position is, even without precedent, this should not go back into the jury room because it may not be considered.
Are you not including number 1 there?
Number 1 is in evidence. Number one-
Well, all of these are in evidence right
No,
now.
but I'm talking about in the state's case in chief.
Right, and that's what I was saying.
We would object.
You're distinguishing 71, 72, and 73, which did not come in case in chief. They're
The state used the one photograph, Exhibit 1, for aggravation. That was what he published for EHAB.
that's going back.
And I objected to the comparison, when he compared that. All right, so I made a proper objection there. I didn't know that Mr. Diaz was going to, all right, so you understand.
Yeah, I understand.
All right.
Mr. Diaz, what's the point of these going back if the instruction says that they cannot consider victim impact?
Judge, it says that victim impact statements cannot be considered for the purpose of aggravation. I know that Your Honor has already made this ruling, and so I'm not trying to disturb Your Honor's ruling, but I do not agree with that ruling.
Which ruling?
I believe that in the fifth step of whether or not the defendant should be sentenced to death, right?
Right.
It says already having found that aggravators exist, already having found the aggravators
There's a
exist.
whole bunch of Supreme Courts. You don't agree with the Supreme Court opinion. I'm just following the law, Mr. Diaz. You don't agree with what the Supreme Court said on that.
No, Your Honor, I don't believe that that's what the cases say. When we had that argument, they pointed to the sentence from the jury instructions, which is again in the aggravating factors section. Regardless, I want to make sure this record is clear. I put those photos in before the first person who testified to victim impact statement, meaning Kelly Andrews and Carrie Rebels, opened their mouth in this courtroom. I put them in. I put them all in as a packet before either one of those people actually got on the stand.
There's no question about that. But which of the aggravating factors, that's all they consider, or mitigating circumstances, do these go to? These were used during the victim impact statements, which were not introduced, which they've been told, they've been given the instruction on. So which of the aggravating circumstances do these additional photographs go to, and tell me how they assist in deciding those?
Judge, the rules are the evidence goes back to the jury.
Well,
Judge, yeah,
That's the rule.
the evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Kay Baker's death. However, you may not consider this evidence as an aggravating factor. They are only right now going through the jury instructions and the verdict form. The verdict form says nothing about victim impact evidence. Notwithstanding the fact it was introduced as exhibits, we are asking this court to rule as a matter of law that they should not go back into the jury room.
I'm not going to let these go back. I'm letting one go back. I may be wrong, Mr. Diaz, but following the law that I believe it to be, I don't see any basis for them to consider these. They saw them. You made argument related to them. They have that. They're armed with that knowledge. But as far as them going back, I'm going to allow them to be removed. They can become court exhibits, or however you want to do it, or if my order is sufficient to say that 71, 72, and 73 is not going to be sent back to the jury room. I don't care how the record reflects it, but pursuant to that, they can't consider it except for uniqueness. I'm not going to let it go back.
All right, then I want the court to ask Mr. Kane, as an officer of the court, that before I gave my closing, I specifically showed him State's Exhibit 73 and State's Exhibit 1, and I told him that that was the only two photos I was going to use, and he said no objection.
I agree.
Okay.
That doesn't mean they go back in the jury room.
Okay, that's fine, but I want to make sure that there's no issue that now I showed them something during closing that wasn't an exhibit, because that's the new problem that's been created. You've just taken 73 out as an exhibit, and I showed it during my closing.
Yeah, Your Honor, that is not an issue.
Okay. All right. Well, you said it's not an issue on the record, so it's not an issue.
It's not going back in the jury room is what I'm saying. That's all I'm saying.
All right. I'm not. I'll let it go back.
Thank you. The stuff that we want to do. Mr. Terry would like to address the court, sir.
I suppose that he can't.
I would just like to have the record corrected and reflected some statements that I made 2 or 3 days ago in respect to testifying.
Okay.
I was, in fact, promised something in exchange for not testifying in the guilt phase of the trial.
What were you promised?
I was promised a accurate depiction of the incident that occurred the night my girlfriend, Kay Baker, died, as I had witnessed it. However,
Judge, if I could just caution my client, he can tell you whatever he wants.
But
I just want to caution him.
It can't be used against him.
Absolutely.
Judge, I would ask that you
and
place
can
him under
affect
oath.
his appeal.
All right. He's under oath. I'll remind him he's under oath. I swore him in when and I want to correct you. I want to make sure you said something that you said a couple days ago. Today I asked you whether you wanted to testify in the guilt phase, and then when you said you had made a decision and that was your decision, I asked you whether anyone forced you, threatened you, or promised you anything, and you did, and you answered that you had not today.
You meant penalty, Judge, because you
Penalty,
said guilty.
penalty. Today.
I'm referring to guilt, Your Honor.
Oh, you're referring to guilt. Well, okay. So you're alleging that in the guilt phase, you were promised if you did not testify in the guilt phase, or if you did not testify in the penalty phase,
I did not testify in the guilt phase.
that you would be provided.
That in the closing arguments, an accurate depiction would have been described in respect to the incident as I had witnessed it.
In the closing argument in the guilt phase.
Yes. And it was not.
You waited, though, till now after the penalty phase to raise this.
I have been talking, I wanted to do this sooner. I made the decision today that I wanted to at least correct the record.
Okay.
And
All right.
I want the record to reflect that a promise was made.
Okay.
And in exchange for not testifying.
Okay. I hear you.
And if you decide we want to, bring this up at another hearing or something like that, that's fine. I just want the record to reflect that.
Okay. There may be post-trial motions related to it that we can discuss, but while it's now fresh and on the record, I'll see if there's any response from counsel.
Judge, if I respond, I would be violating attorney-client privilege, so unless I am ordered to give that kind of information, or unless there is a 3.850, I am restricted from doing so.
Well, I think that it can be addressed at the appropriate time. I think it's premature to make such an order or requirement, or that what has happened thus far constitutes a waiver of attorney-client privilege. So it's on the record, and certainly at some subsequent appropriate time, then you may have the opportunity to respond.
Yes.
Mr. Diaz, anything?
I would ask Your Honor to ask the defendant what it is that he wanted said, so the record is clear.
Objection, that's not necessary to get into right now. As the court has said, the assertion has been made by Mr. Terry on the record, and if at some later date it is undertaken by either a 3850 court or somebody else, then it will be addressed.
No, that's different. And he has the opportunity to change his mind. That's totally different. He brought this up. He broached this subject. I will ask him. He can decline if he wishes.
Would you please remind him that
What he
again,
says, he's under oath.
If we could have a couple minutes with Mr. Terry.
I'll allow you to talk to him.
Thank you.
Can we take this up in just a moment and get the jury is waiting for the evidence. So come over here, make sure that everything's good to go back, and they can start deliberating. were made a promise by your defense attorneys regarding or related to your decision not to testify in the guilt phase of this trial. And you've indicated that that promise was for, say it again, a representation of what happened during the closing argument?
An accurate representation
Accurate
of what happened
representation.
during the closing arguments
Okay.
that evening as I had witnessed them.
And you feel as though that was not done?
Correct.
Well, I'm going to ask you now what that accurate representation is.
Because I think he wants to address that at an appropriate hearing, which would not be today, because of course the court indicated already that it would be premature now to do anything else, maybe in the future at any post-conviction. So I believe right now he doesn't want to expand on that any further than what he wanted to originally put on the record was the statement he already said.
I'm not going to order him to, but this is his opportunity to make a record of what he believes is the issue. So I'm going to give him the opportunity to make that record at this time.
I believe he feels like he's made
Well,
the
he has to
record. I
answer.
understand that, but I believe his position is going to be that he's made the record adequately that he wanted to at this juncture.
Yes, Your Honor, I do feel like I have already communicated what I wanted to Your Honor and to the court, and I think that the rest of this should be handled at the appropriate time. My only intention was just to bring this up so it was on record today. That is all.
All right, I'm going to accept that. I'm going to leave it at that.
Thank you.
You're welcome. Anything, did I already ask any objections to the instructions as given from the defense?
You did ask, and we did
All right.
not have any.
All right.
Judge, is this then going to invalidate the defendant's answer that he gave you earlier, that he said that he was also satisfied with the representations of his counsel? Because I believe you asked him that at the conclusion of the verdict, which by then he would have known what was already said during closing argument.
That's not an appropriate legal question for me to determine at this time, Mr. Diaz. Seriously?
I'm not asking you to determine, I'm asking you to inquire of the defendant. Because
That's
what's
not
going,
appropriate at this time.
Judge, what's going to happen going forward in the future is we're going to have to rely on the words that were said of the defendant.
Which is that he was satisfied.
Yes, and so is he asserting that somebody threatened him or promised him something then? Because I don't think Your Honor asked him that.
He hasn't changed that answer, Mr. Diaz.
Yes, Your Honor.
Judge, the final issue is, you may recall with the Richardson issue, I moved for prosecutorial sanctions. I do not know if you wanted to rule on that at this time, or if you want to do that at another time.
No, I'll pass on that at this time as well.
Certainly.
More appropriate time.
That's fine. Whenever you feel is appropriate.
All right. I'll let you know. Anything else?
Anything else? No, Your Honor, other than, of course, we renew all of our prior objections and our prior motions.
Absolutely. Same rulings. Anything else from the state? All right. Thank you.
The scheduling plan, Judge, is to let them deliberate for as long as they want to, and you were talking about possibly feeding them.
Absolutely.
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 If we get there.
Since we did an early lunch and they came back at 1 o'clock today, at 5 o'clock I'll instruct the bailiff to go in and see if they would like for us to start ordering food, because it does take about an hour.
Okay, thank you.
All right. You're very welcome. Thank you. present, as are all attorneys. You may be seated. I've been informed that the jury has a verdict on the penalty phase. And we're going to get to that in a moment. But before we get too far from what happened before we broke, I want to readdress that. I'm concerned in that Mr. Terry has made an allegation that his attorneys lied to him. That's exactly what he has alleged. And obviously there is a appropriate 3850 that can be filed and addressed, but the accusation is fresh, and I don't think that I should pass on the opportunity to make a perfect record as we're here. So I don't believe that I can order him. I gave him an opportunity to make any additional record that he wishes to, and I will continue to extend that opportunity to him if he wants to change his mind and put anything on the record. But I think that the most important thing is that I ask you, Miss Perry, whether or not you promised him anything. And if that requires me to find a waiver of attorney-client privilege, I find that because he's alleged that you lied to him in order to get him not to testify in the guilt phase. And so I'm asking you, and I'm finding that it constitutes a waiver. In fact, I'm ordering you to tell me whether you promised Mr. Perry anything in exchange to get him not to testify in the defense case in the guilt phase of this case.
Since I've been ordered, I am permitted to answer, and no, of course I did not.
Okay. All right.
Judge, I apologize, but unfortunately, I don't know that Mr. Terry said that it was Miss Perry that promised him. I'm just trying to play it out logically.
That's true. All right. All right.
So you could just ask Mr. Terry who it is that made the promise to him. and then
I
it
would ask that you instead perhaps just inquire of my colleagues if they made any promises. I don't.
Fine. Mr. Kane, did you make any promises to Mr. Terry regarding anything in order to regarding his decision whether to testify in his case in chief during the guilt phase?
Yes,
You made promises to him?
yes.
What were those promises?
I promised him that Ms. Perry's closing argument, any theories or any interpretations of the evidence would be based upon the admissible evidence, and that she would argue according to the evidence that had been admitted in the case. That she could make no other arguments except what was supported by that evidence.
Okay.
That is the promise that I made.
All right. Any requests from the state at this point?
Judge, I'm deeply troubled by that answer. When a defense attorney stands up and says, yes, I made promises to a client who is now saying I was made promises and I waived my rights in furtherance of the promise, where Mr. Terry is now, I believe, if I understand things correctly, Mr. Terry is basically saying there was some agreement as to what exactly the story would be that would be told to the jury in closing, and that is not the story that was told. I don't know that this has clarified this any better.
Judge, I am answering the court's question. All right, there was more to the discussion on whether or not a client is going to testify than just what has been said here. And I don't know if now is the appropriate time to address that when we have the jury waiting to announce their verdict. So I would ask that any concerns that the court has on this issue be undertaken or addressed after we have received this decision by the jury.
Mr. Diaz, any requests from the state regarding clarification? I mean, this is...
Your Honor, I mean, you have decided that this constitutes a waiver of attorney-client privilege. It is an odd situation for me to suggest what the court should ask, because I don't know that I'm the appropriate person to ask the questions.
I'm asking if you have any suggestions.
Well, I mean, Judge, if attorney-client privilege is waived, I don't understand why you cannot ask the defendant what it is that he believes he was promised, and then you can ask the attorneys individually, did any of you promise that or anything even remotely in that realm? I mean, this is pretty explosive stuff that is
I understand.
happening.
I agree. I mean, it's somewhat even uncharted territory. But I appreciate your suggestion. Mr. Terry, I'm going to ask you what you were promised.
Sir, there were no theories discussed between my attorneys and myself in respect to any other sequence of events except what I described to them. Therefore, when it was told that everything would be covered in closing, I was under the presumption that what I had communicated to them would be communicated to the court instead of me testifying. So essentially I looked at it as a way of them portraying what I had spoken to them in respect to the incidents that occurred that night for me in the closing arguments. And I thought the closing arguments were phenomenal up until the description of the incident, which was not accurate at all. Even though, as Mr. Kane described, it may have fit the context of the evidence, it was nothing close to what I had described to any of my attorneys.
All right. Mr. Kane, did you promise
We never-
that?
No, I never promised Mr. Terry, ever, that what he had detailed for us previously would be theorized or argued by Ms. Perry, never under any circumstances.
Okay.
As a matter of fact, my caveat to him was, the promise we can make is that Ms. Perry's argument will be supported by the evidence, and the evidence alone, and her interpretation and reasonable interpretation based on what can be inferred from the admissible evidence. That is the promise that I
But you
made.
did not specifically promise him that her closing argument would contain anything that he expressed to you regarding a theory of the case.
Under no circumstances did I promise that.
Okay, thank
And
you.
I do
I
not believe
appreciate
that Mr. Terry is saying that I made such a promise.
Well, hold on. Ms. Perry, did you make any such promise to Mr. Terry?
No.
Ms. Spradley, did you make any such promise to Mr. Terry?
No.
Judge, I want to be respectful of the fact that we have a jury waiting. I really do, but
I opened this door, but I was concerned about an allegation of a defendant in a death penalty case that not only implied, but appeared to specifically allege that his attorneys had lied to him.
I agree, Your Honor. I mean, that's what I was concerned about at the beginning. He was basically saying, I was promised something, and then they didn't give me what they promised.
Well, but the attorneys have now said that they did not promise that they would provide a version of anything that he relayed to him. They've all said that on the record. Is there anything additional you want me to ask them?
I mean, I thought that when Your Honor came out, and maybe I misinterpreted what you said, and if I did, forgive me, but I thought you were starting this with, you were going to ask the defendant specifically what it is that he thought was going to be said that was not said.
I said I can't order him to do anything. I would give him the opportunity if he wished to put anything on the record. I did, after, end up asking him specifically in response to your suggestion that I asked him what he was promised. So that did change, and I asked him, and he told me. I will continue to give him the opportunity if he wants to put on the record what his version is, but his attorneys have specifically indicated, each and every one of them individually, that they did not promise him that they would provide a representation of what his version was in order to get him to waive, to not testify. That's what they've said.
Well, I would ask Your Honor, or at least I would ask Your Honor to tell Mr. Terry that he has this opportunity to say on the record whatever it is, whatever fact, specific fact that he thinks should have been said or was going to be said that was
I
not
said that I would, and I will.
And I'd also ask that you would clarify with him, I guess, why when the closing was done and Ms. Perry sat down, there was no issue raised in that moment.
Judge, the prosecutor may want to question Mr. Terry, but he doesn't have the right to. Those are not appropriate questions. This is not.
Well, I've already put on the record that he waited, that he didn't say anything about it until now. But I will give him the opportunity. Mr. Terry, if there's anything that you would like to put on the record now, we're making a record for a number of post-trial issues that may be associated with your conviction in this case. So I'm giving you the opportunity now, if you want to say what it is that you believe that they were going to include in their closing argument and did not, and that they promised you in exchange for you testifying, I'm giving you an opportunity to tell us now.
I felt that I was promised that a depiction of the accurate sequence of events as I had witnessed them were going to be portrayed in closing. Possibly not exactly or every single detail, but at least an accurate depiction of what happened that night as I had explained it to him. That was my perception and that was my belief. I have been in discussion with my attorneys about this incident since the end of closing. And today I decided I wanted to raise the issue against their advice. I wanted to raise the issue and at least have the record reflected that I didn't even realize I was promised anything until after closing. But then I realized that that is not what I expected.
Okay, there's a big difference between expectations, promises, and the questioning that I gave to you prior to when you told me you had made a decision not to testify. If you didn't realize that you were promised anything before you made that decision, is that what you're telling me?
Yes.
Okay, all right. Thank you very much. That's
Thank you, Your Honor.
Let's get the jury. jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. The bailiffs have indicated to me that you have reached a verdict in the penalty phase of this case. I'm going to turn now to Mr. Williams as the foreperson of the jury. Is that in fact correct, Mr. Williams?
Yes, Your Honor.
Do you have the verdict form for the penalty phase?
Yes, Your Honor.
Could you please present that to the bailiff? Thank you, sir. I will review the verdict. I will then present it to the clerk to be published. Mr. Terry, if you will please stand, Mr. Counsel, for the publishing of the verdict.
State of Florida versus Matthew Robertson Terry, case number 22 CF 006969. We, the jury, find as follows as to Matthew Terry in this case. A. Aggravating factors as to count 1. 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Matthew Terry was previously convicted of a felony involving the use or threat of violence to another person. Check. Only yes or no. Yes was checked. Number 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder was especially heinous, atrocious, or cruel. Check. Only yes or no, and that answer was no. If you answered no to every aggravating factor listed, do not proceed to Section B. B. Sufficiency of the aggravating factors as to count 1. The answer is no. Dated this 17th day of November 2022 in Hillsborough County. Foreperson, signed by the foreperson, W.W.
Thank you, Madam Clerk. You may be seated. Would either side like the jury polled before they are released by the court?
No, Your Honor.
All right. Anything else that we need to address before the court releases this jury? State?
Nothing, Your Honor. Thank you.
Defense?
Nothing, Your Honor. Thank you.
All right. Ladies and gentlemen of the jury, this is my final opportunity to address you. And the first thing that I want to say is one of the first things that I said to you 3 weeks ago when we brought you in here. And that is thank you for your very important civic duty. I indicated to you during jury selection that jury service is one of the most important things that you can do for your country. And I am quoting Abraham Lincoln. You have completed that very important service, and we greatly appreciate you. I know that it wasn't easy. I know that it was long. You've been here now for 3 weeks. Not only do I thank you, but I appreciate you, and I thank you for your patience with us. All of my prior restrictions regarding doing any research about this case, about discussing this case with anyone, I am going to release you of at this time. That means that as you walk out that door in just a moment, you are free to either continue discussing this case amongst yourselves, but also to discuss it with others. It is entirely your decision and your decision alone whether you wish to do that. If you do not want to discuss it with anyone else, you do not have to. Additionally, there is a very special protection that applies to your deliberations, both during the guilt phase and in the penalty phase. That is that you cannot be forced to talk about your deliberations except by court order. Again, though, that is your decision. If you wish to do so, then you may discuss with others your deliberations. As far as everything in the case, anything that may be out there on media, social media, you are free to look at that if you wish. I cannot say it enough, so I'm going to say it one last time as I dismiss you from the courtroom, and that is thank you sincerely. All rise for the jury. Jury has exited. Everyone may be seated. There are no options regarding sentencing. What is the state's request?
Your Honor, we'd ask to proceed to sentencing. The family is here from out of town.
All right. I don't see any reason not to.
Your Honor, can I just have a
Yes.
minute to confer with him?
Yes.
There's no legal reason, defense agrees.
Okay, thank you.
Your Honor,
Yes.
so that the sentencing order is complete, Mr. Terry has 170.
Court, I think only Christine MB case stepmother would like to address the court at some point if you have a chance. And then otherwise we can proceed as
Yeah,
normal.
absolutely. Absolutely. Anyone who wants to address the court may. We're going to proceed to sentencing at this time, so she may come forward. We'll just put her at the podium there, unless she wants to come down to the witness stand, wherever she's more comfortable.
And would you rather stand?
You want to go to the podium, or do you want to come sit in the chair?
I'll come sit in the chair.
All right, let me swear you in before you walk over there. If you'll face me and raise your right hand, please. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed to the chair. Did you want, I don't see any reason why you can't go with her. This is victim's assistance.
Yes. Can we just maybe set a chair up over here for her?
You want to just put that chair right over here? Is that sufficient? Is that all right with you, ma'am? And Mr. Diaz, I apologize. Please state her name again.
Yes, this is Christine Empey. E-M-P-E-Y.
Welcome, Ms. Empey.
Thank you.
I'm going to allow Mr. Diaz the opportunity to ask you questions.
Ms. Empey, just a little bit of background so His Honor understands. You are the stepmother of Kay Baker,
Yes,
and how long have you been her stepmother?
35 years.
All right, so that's the majority of her life.
Yes,
Do you have something you'd like to say here in court?
yes, I do.
Please proceed.
What words did Kay say that night to justify you killing her? How bad could those words be? Did she say, Dad was right? Michelle was right? Was that what got her a death sentence? It is very unsettling as a parent to fear for your daughter because of the partner they've chosen. I feared for Kay's life. Her dad feared for Kay's life. And I don't understand why she did not. I hope you fear for your life.
Thank you, ma'am. Let me get seated. Mr. Diaz, did you have any questions?
No, Your Honor, thank you.
Does the defense have any questions?
No, Judge.
Thank you. Then you may step down. Would anybody else like to be heard?
Yes, Your Honor. This is Jessica Cook. She'd like to address the court.
Ms. Cook, come on down. I'll give you the same choice, Ms. Cook, if you want to stand at that or if you'd like to come down. Let me swear you in here. Do you swear any testimony you give will be the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Thank you, ma'am. You'll come all around to the chair. Watch your step. Go ahead and have a seat. Make yourself comfortable. Yes, do you want to start off with a question?
Yes, Your Honor. Yes, Your Honor. Thank you. Ma'am, could you please tell us how you know Matthew Terry?
I was his college girlfriend. We went to different colleges, but we dated almost 20 years ago.
Okay. And do you have something you'd like to say here to the court?
I do.
Okay, please go ahead.
Am I allowed to address Mr. Terry?
Yes.
Okay.
Objection, Your Honor. These proceedings are not to be having the witnesses address the defendant directly. The requirement is that they address the court. We didn't
I can do that as well.
All right, go ahead and address.
I can do that as well.
Address me.
Okay. I have sat here this week and listened to everything that has happened, everything that has been said. I have watched the giggles and the laughs and the complete disrespect for a woman's life. That woman is not here today. She has passed away. And I feel like it's a slap in the face, especially when I heard that there were no priors, when you were given instruction that there were. I was not allowed to testify in any of this because I accepted misdemeanors rather than pushing for a trial in felonies. And because of that...
Let me end this for a second, Coach.
I'm going to overrule whatever the objection is. I'll allow it.
If I could just have access to the record, please.
I'm sorry?
If I could have access to the record, please.
You can have it from there.
Yes, the access to the record is that the purposes of these proceedings with providing victim impact, my understanding is that Ms. Cook is now taking the opportunity to denigrate the defense and to criticize the defense without proper foundation. And we would just object to any further statements about the defense if she would like to confine her victim impact, not fully knowing the relationship that she may or may not have had with Kay Baker. We can then address the appropriateness of her taking a stand and making these remarks.
Your objection is noted. You may proceed.
Ma'am, just a little bit, because I think the judge may not understand what you're talking about. Were you the victim in another case involving Mr. Terry?
Yes, I was.
When was
Overruled.
when was that?
Early 2000s.
And can you just give a brief summary of what happened in that case?
Yes. He broke into my house. I was assaulted. My girlfriend, which was not in a lesbian sense, my friend that was a woman, was also assaulted. And he chased us around the house. When the police came, he pretended to be the victim rather than the assailant. And a lot of the things I heard today regarding Kay's, or not today rather, but this week, were very similar to the things that I endured. And so I did not plan on saying anything today. I did not plan on being a part of this at all. But I feel that Kay deserves that support. She trusted this man wholeheartedly. She has for years. I have known of Kay since we dated. She was a good person. She was a beautiful soul. And she loved this man wholeheartedly and would have done anything for him.
Is there anything else you'd like the court to know?
No, that was it.
Thank you, ma'am. Pass the witness.
Any questions?
No questions?
Thank you, ma'am. You may step down. Mr. Diaz, anyone else?
No, Your Honor, that's it for witnesses that we'd like to present.
All right, let me see if there's any witnesses from the defense.
No witness.
All right. And does Mr. Terry wish to address the court?
Yes, sir.
All right.
Your Honor, there's only one lawful sentence. I hate to say that you don't have discretion, but you don't have discretion, so I would just ask that you impose the lawfully required sentence.
Anything from the defense?
Nothing further.
All right. Yes, please stand. I guess in one respect it is easy, since Mr. Diaz is absolutely right and that I don't have any discretion. There is only one sentence. What I will say is that I listened to the testimony of Ms. Rogers both during the Williams Rule hearing and during the trial that we've been in here, and additional testimony regarding the charges, the trial, the sentence in Michigan. I don't know what happened in Michigan as far as the trial and the sentence, but based on what I heard, I believe that you should have been in prison in Michigan and that Miss Baker should still be alive. This is Florida. You're going to prison for the rest of your life. I adjudicate you guilty. I sentence you to life in prison. I impose all fines, fees, associated charges, and I advise you that you have 30 days to appeal the judgment and sentence entered against you. Thank you.
And the credit time, Judge?
He has 174 days credit. State, any objection?
No, Your Honor.
All right. Thank you all very much. Thank you.